In 1999, a California attorney by the name of Scott Donahey was assigned to be the panelist in the very first case ever filed under the brand new UDRP, the Uniform Domain Name Dispute Resolution Policy.
It was very easy decision, and even the parties recognized that prior to my decision. But to give people a feel of why it made sense to use the UDRP method of decision rather than go to court.
At that time, domain name disputes were relatively new, with most cases being litigated in court, which made for a challenging, lengthy, and expensive process. But the UDRP changed everything, and it quickly became the most common way for trademark owners to take on cyber squatters. But in 1999, the UDRP was not well known when World Wrestling Federation Entertainment Incorporated filed its complaint for the domain name worldwrestlingfederation.com. Interestingly, the company already had a much shorter and presumably desirable domain name, wwf.com, but it apparently decided to file a UDRP complaint when the registrant of worldwrestlingfederation.com tried to sell the domain name to it for $1,000. The complaint was filed at WIPO, the World Intellectual Property Organization, and Scott Donahey was tasked not only with writing the first UDRP decision and deciding whether to transfer the domain name to the World Wrestling Federation, which he did, but also to explain to the world in his decision what the UDRP was and why he reached the conclusions that he did. So Scott went on to write hundreds of decisions under the UDRP and became an authority on domain name disputes in those early years, while also maintaining his legal practice as an arbitrator for international intellectual property disputes involving hundreds of millions of dollars. I had the privilege of serving with Scott as a domain name panelist at WIPO for many years, and it has occurred to me that relatively few people know or appreciate the important role he took on in writing that very first decision. So I recently had the opportunity to talk with Scott, who is now retired from the practice of law and his role as a UDRP panelist, about what it was like to do something that no one had ever done before. So Scott, I've known you for a long time because we both served as UDRP panelists at WIPO at the World Intellectual Property Organization. I know you're retired now, but it's really nice to have you here and talk to you today. For those who don't know who you are, can you tell us a little bit about your legal background and your legal experience, and then we'll start talking about the UDRP in particular.
Okay, once I graduated from law school, I went to Santa Clara University Law School. I started practicing litigation, and that practice evolved into primarily intellectual property litigation. And I did a lot of arbitration work. I've served as an arbitrator for many, many years with different entities. And then when this came along, I was talking about arbitration law and arbitration law of intellectual property at a convention. I can't remember which convention it was. And after I spoke, Francis Gurry came up, and I was still on stage, and he was down below and looked up and said, you know, I'd like to talk to you, have a cup of coffee, and talk to you about project I'm having, and like you see if you would want to be on the panel. And
just to interrupt, for those who don't know, Francis Gurry was at the time with WIPO and would go on to become the Director General of WIPO,
yes,
correct?
Yeah. And so I spoke with him, and he asked me if I would be interested in taking cases for this new policy that was being adopted. And I said, certainly. And so that's how it started.
The new policy, of course, being the UDRP, the Uniform Dispute Resolution Policy, which, you know, rolls off the tongue easily now, but we're talking, I assume, 1999
yes,
or thereabouts.
We're talking 1999.
Okay.
in the fall of 1999, as I recall.
So
Yeah.
I'm curious, had you handled or been exposed to domain name disputes in any way prior to the UDRP? You know, a lot of people equate domain name disputes and the UDRP as the same thing, but there were, you know, maybe not many, but there were a number of domain name disputes, you know, prior to the UDRP in the courts and through other arbitration type of policies.
Yeah, I personally hadn't handled them, but I had read about some of the cases at that time. And so I knew little about it, but not
Right,
little.
right. So Francis Gurry convinced you to become the first or one of the first domain name panelists for the UDRP at WIPO. Is that correct?
That's correct. Yeah, and he brought me on board to be to do the first decision. So
Right, right. Yes. And the reason we're talking is because I've known for a long time, and I just don't know how many other people know it, but I feel like a lot of people should know it, that you were the panelist for the very first UDRP decision. It's actually
yes, and for all of the decisions, I was a panelist for all of the decisions that were uh, issued in 1999 because there was only one.
That's correct. Yes, as a matter of
Just
fact, yeah. So the decision has a was the complaint was filed in 1999. The decision did not come out until 2000.
yeah,
But so you're right. It is the only decision with a 1999 date, and it's actually interesting to sort of look at the case citation. You know, for those who remember the Y2K bug and all the fears about that. You know, it's interesting to actually look at the case citation, and it includes the number 99, which I think
yes,
later was changed to 1999 to indicate the year of the case.
right,
So the case was actually for the domain name
correct.
worldwrestlingfederation.com.
Yes.
What do you remember about that case?
Well, I remember I had to apply the policy for the first time, and what I was trying to do in the case is uh, give my understanding of what the policy represented, what it stood for, how it should be interpreted. And so it was a sort of a definition case. In other words, I was trying to define some of the terms and is, see if they stuck or not. My definition stuck or not. And it was kind of a common law approach to um, the UDRP, developing the meanings of the thing and the variations thereof.
Right. So unlike the courts, I suppose, you did not need to explain what a domain name was and what the internet was, which is what happened in some of the earlier decisions that first dealt with those issues in the mid 90s, 1995, 96, 97, maybe. So the UDRP, presumably anybody who was involved with a domain name dispute decision uh, or case knew what the issues were about, but the UDRP itself and its three-part test, and what the remedies are and who's bound by it, nobody really understood those things when you got the World Wrestling Federation case, right?
That's correct. And basically, I was trying to give a broad, not only to decide the case itself, but to give a very broad picture of what the UDRP was and what it meant to users.
And I think you did a fantastic job, but how did you realize that that was important? Because, the UDRP now has become and has for many years, been the primary way that trademark owners use to resolve cyber squatting issues. But that was not clear in 1999 or 2000. So you were very forward thinking about explaining what the UDRP was in your actual decision.
Well, I tried to be anyway. I just wanted to give a grounding for people as to why it made sense to use the UDRP and to use the WIPO at that time, which was one of the major, if not the only provider. And it just so happened that I'd met Francis Gurry at a program I was doing on intellectual property generally, and I could still see I was on the stage and he was down below. He was still taller than I was. Um, but we talked and he asked me, would I be interested in this? And that's how it started.
There are a lot of things that happened in that very first decision that we've seen repeat a lot through the years. For example, there was no response filed in that case. The
Right.
domain name itself was actually not being used in connection with an active website. The
Correct.
registrant of the domain name was trying to sell it to the trademark owner. So that very first case was full of a lot of interesting facts that played out in the tens of thousands of decisions that we've seen since then.
Yes. Yeah. So it was a first impression, case of first impression.
Yes, exactly. Which meant, of course, that there were no previous UDRP decisions for you to cite in
That's right.
writing the very first UDRP decision. I mean, I've written a lot of UDRP decisions as a panelist through the year, and I like to, respect precedent. I think it's good for the process. It lets the parties know what to expect. And so when I write decisions, I like to support my conclusions with citations to previous UDRP decisions, but you couldn't do that. I think you cited to one or two previous court decisions,
I did.
those involving Dennis Topin,
Right.
who at the time was well known as a defendant in domain name disputes. But that's all you could cite, that and the UDRP policy itself.
Yes, that's correct. And try to give a feeling for a broad brush interpretation of it so that people could take it from there and they did and refined it considerably.
Yes, yes, exactly. Um, and you went on. Any idea how many decisions you ended up writing through the years? I know you're retired now.
Gosh, I have no idea. Hundreds. I don't know if it got to 1,000, but it was a lot of cases.
Right. And any of them in particular, besides the very first decision, stick out in your mind?
Mm, no, not really. I do, there were a lot of interesting cases that I did, but none that the first case was, of course, the one that stood out for me because
Right.
basically I was trying to uh, uh, not so much decide the case, which is pretty much it was very easy decision, and even the parties recognized that prior to my decision, but uh, to give people a feel of why it made sense to use the UDRP method of decision rather than go to court, and that it did provide a methodology by which any citizen or individual would be able to file a case and be able to afford it so that they didn't have to try to go to court and spend a lot of money.
Yeah, and you're right. You did actually refer to that specifically in your decision. Just to read a couple of sentences from your actual decision. Uh, you said complainant acknowledged that it could have proceeded to litigation under the United States Anti-Cyber Squatting Consumer Protection Act, but that it elected not to. By engaging in this proceeding, complainant has sought to protect complainant's intellectual property interests while preserving the relationship between complainant and its fans at a minimal cost to all concerned. That's another issue that we have seen a lot of through the years.
Yes,
So-called fan types of sites. But you're emphasizing that I think from this very first decision that the UDRP was and still is, a relatively inexpensive and quick means of resolving these types of disputes.
Yes, it was, it really would have been uh, uneconomical for many parties to get a decision in a courtroom because they'd have to spend more money than what the reassigning the domain name might benefit them. They it would have cost them so much that it didn't really justify.
Right, right. Now, I think on the one hand, nothing has changed since that first decision. The UDRP policy still has the exact same three-part test. Um, on the other hand, I think a lot of the activities that cyber squatters engage in today, whether it's phishing or tech support scams or malware or bulk registration and use of domain names, are things are those issues that I know it's been a few years now, but do you think you could have envisioned any of those issues back in 1999?
I certainly didn't. I don't know if some people weren't more foresightful than I was, but uh, I was just trying to say, look, it's too expensive for you to take this case to court. It makes a lot of sense to do it. You've got rules, you've got policy here, and it's going to save you a lot of money and make the whole result faster, because that was another concern, that if they appealed the decision and went up and up, it could end up costing them more money than the case was worth. So
And
you
that's
just
interesting
would
because
just abandon the case.
that one of the criticisms actually of the UDRP is that there is no appeals process. There are other domain name dispute policies like the nominet process for .uk domain names, that specifically have an appeals process built into them. But for better or worse, the UDRP does not, and I think that. Or what are your thoughts about that?
Well, I think if you've got the money and it's worth the fight, to the domain name is that important to you and your business, that's an advantage to have that appellate process available to you. But for the most part, a lot of the cases that we were seeing, especially early on, were cases that respondent didn't even feel the need to file a response. They just didn't really care. Uh, but if they thought that it was worth it, they could delay and delay and delay in a court situation and maybe convince the complainant that it wasn't worth the money to the complainant to get the domain name back.
And what's interesting, I think, too, is that it doesn't matter who the complainant is, the complainant being the trademark owner who files the dispute.
Right.
The same UDRP policy applies whether you are a solo entrepreneur, or a small business owner, or you're a Fortune 5 company. And everybody, from the smallest to the biggest, use the UDRP.
Yes, I was really surprised how and, uh, provingly surprised that it really became the primary means of retrieving a domain name that someone else was using.
Yes, I think, and the numbers are proving that very true. For the last 9 years now, the number of UDRP decisions has been on the rise. So, WIPO
Oh,
was referred.
is that true? I didn't realize that. I haven't been following that, but it's increasing every year, huh?
That's exactly right.
Wow.
WIPO has referred to it as a surge in cyber squatting.
Ah,
And I think there are a number of reasons for that, but regardless, the UDRP and the other domain name dispute policies, some of which are based on the UDRP, are being frequently used. And I think thanks to you and your foresight in the very first decision, the UDRP has proven to be a very effective tool for trademark owners and for the benefit of everybody who uses the internet, really.
yes, well, it saves a lot of time and a lot of money, and it gives someone a short span of time between the filing of the complaint and the result, which would make it economically attractive.
Right. Yes. And everything is relative though. So,
Yes,
a decision under the UDRP, typically takes about 2 months to resolve from filing a complaint to actually getting a decision
that's
as com-
good.
which is good compared to litigating, obviously, which could drag on for years and cost many, many times what a UDRP proceeding would cost. On the other hand, and I know this from my trademark owner clients, sometimes every day that a cyber squatter continues to hold on to a disputed domain name is potentially causing a problem. And so two
Of course.
months, sometimes can look like a very long period of time.
Well, I'm sure it can, but compared to other means of getting a domain name, besides breaking and entering, I think it is as quick as you possibly could uh, have a decision without spending lots and lots of money on it.
Right. Any other thoughts that you wanted to add? Anything?
No, it's just bad faith is a fairly general statement. In fact, it's so general that until somebody tells you what it means, you're really not sure what it is. And
Right. But
that was one of the things that I thought was something that needed to be developed, and of course, it was over time.
right, exactly. And what you're referring to is the third element of the UDRP, which states that a trademark owner has to show that the domain name was registered and is being used in bad faith.
Right,
And there are definitions in the UDRP of what bad faith means, but I found it fascinating because there has been a little bit of a controversy, or there used to be a controversy within the UDRP about that language because of the word and. You have to show that the domain name was registered and is being used in bad faith. And in that very
that's correct.
first decision, the World Wrestling Federation decision, the domain name itself was arguably not being used because there was
That's
no
correct.
website associated with it. It's just that the registrant of the domain name was trying to sell it to the trademark owner. So you actually had to address that issue in the very first decision about whether there was registration and use in bad faith.
Right. And that was important because otherwise the person that was let's say seeking money for the domain name could just sit there and hold on to it until they got the price that they wanted, and this was a way to use use had to be defined in a way that made it possible for cases to be filed, even when technically it wasn't itself being employed by the registrant to harm, if you will, the defendant's business.
Right. And so I think what's really interesting, and there was no way, I mean, maybe you had incredible foresight, and I'm sure you did. But I would not have had the foresight that you did back in 1999 to think through those issues. And if you look at the language of the UDRP, there's one definition of bad faith, which refers to registering it to sell it in excess of your documented out-of-pocket cost directly related to the domain name, and that shall be evidence of the registration and use of the
Right,
domain name in bad faith. And that's the language that you actually relied on and cited in writing that decision.
right. Yeah, that's true. And but I think that it's amazing to me that there's still so many cases being filed that you brought to my attention, because uh, it is an expeditious and cost-effective process. But still, it's a lot of money to spend if uh, you think after all this time, uh, people would avoid registering those names because they would be taken away anyway in a very expeditious process.
Right. Well, I think the economics are it's a lot less expensive to register and maintain a domain name than it is to file a UDRP complaint.
Yes,
Um,
yes, that's true.
so,
Yeah.
well, again, Scott, thank you for your very first UDRP decision at WIPO and for all that you've contributed to the UDRP jurisprudence through your years of practice until your recent retirement.
Well, thank you, Doug. I appreciate that.